The ID left his hand at 9:41 p.m. on a Friday on the shoulder of the Baltimore-Washington Parkway, 3 miles north of the Powder Mill Road interchange in Prince George's County, Maryland, and it hit the asphalt before the man did. He did not fall hard. He caught the door frame with his left hand, which slowed him, and he went down on one knee on the gravel at the edge of the shoulder, rather than all the way to the ground. But the knee came down, and his palm came down beside it, and the ID, a laminated card, cream-colored with the gold-embossed seal of the Supreme Court of the United States in the upper left corner, skittered across the asphalt and stopped against the tire of his own car. The officer who had put him there was still standing, both hands at his sides, chest up. The patrol car's lights were going behind him, red and blue cycling across the trees on both sides of the parkway. And in that light, the man on one knee on the shoulder of the road was visible to the 3 other cars that had slowed when they saw the stop. One of them, a dark green Volvo with Maryland plates, had pulled over 40 yards back. Its driver had not yet gotten out. The man on the ground did not shout. He did not make any sudden movements. He placed both palms flat on the asphalt, the way you place your hands when you are preparing to stand, and he stood, slowly and without assistance, and he brushed the gravel from his right knee with 2 careful passes of his hand, and then he turned and looked at the officer. The officer said, "You were doing 79 and a 65. The man said nothing. "I need to see your license and registration." "You have my identification," the man said. His voice was even. It was not the evenness of someone suppressing something. It was the evenness of a man of 73 who had spent half a century in rooms where the wrong word at the wrong moment had consequences that could not be undone, and who had therefore built a practice of choosing words the way a surgeon chooses instruments, for fitness, for precision, for the work the moment required. "That's not a driver's license," the officer said. "No," the man said. "It is not." He bent, slowly, with the particular care of a man whose knees gave him news about the weather 3 days in advance, and picked the card up from beside the tire. He held it out toward the officer. The officer looked at it. He looked at the gold seal. He looked at the man in the gray suit with the gravel dust on his right knee. He looked at the car, a dark blue 2019 Lexus LS with 61,000 miles on the odometer, registered in Montgomery County. He looked at the seal again. "Where'd you get this?" he said. The man who was on one knee at the edge of the Baltimore-Washington Parkway at 9:41 p.m. was named Justice Kwadwo Emmanuel Owusu Boateng, Associate Justice of the Supreme Court of the United States, retired. He had served on the court for 27 years, from his appointment in 1993 to his retirement in 2020. He was 73 years old. He was 5 feet 10 and weighed 177 pounds, which was within 3 pounds of what he had weighed on the day he was sworn in, a fact his doctor mentioned approvingly every year, and which Kwadwo himself never thought about. He wore a gray wool suit that had been made for him by a tailor on Wisconsin Avenue in Chevy Chase in 2011, let out once at the waist in 2015, and dry cleaned with such regularity that the label inside the collar was beginning to fade. Beneath the jacket he wore a white shirt and a tie that had belonged to his father. Dark blue silk, small gold diamonds in the pattern, bought in Accra in 1971 before his father emigrated, worn by him to every professional occasion of significance for 49 years until he died in 2017, at which point Kwadwo had taken it and worn it to every professional occasion of significance since, because it seemed like the right way to carry a person. He was driving home from a dinner at the Georgetown home of a former colleague, a woman named Justice Constance Amma Pauline Mensah, now also retired, who held dinner every 3rd Friday of the month for whoever of their old circle was available and willing to argue about constitutional history for 3 hours over jollof rice and fried plantain. There were usually 6 or 7 people. Tonight there had been 9, because 2 former clerks had come in from New York, and the argument about the original meaning of the Privileges or Immunities Clause had gone until 9:15 and had ended only because the former clerk from New York, who had been most animated about it, had a train to catch. Kwadwo had left at 9:22. He was 17 minutes from his home in Silver Spring. He had been doing 79 and a 65, which was true. He had been listening to a recording of a string quartet on the car stereo, Beethoven, Opus 132, the third movement, which required no attention and all of it simultaneously, and the speed had crept up the way speed does on a highway at night when the road is empty, and the music is pulling you forward. He carried the Supreme Court credential because he had carried it for 27 years, and had never unlearned the habit. He carried it in the inner breast pocket of every suit jacket, behind the pen, a Pelican M400, black with gold fittings, given to him by his first law clerk in 1994, with a card that said "For the opinions that matter," which he still used to sign his name, in correspondence, on documents, on the birthday cards he sent by hand to his 9 grandchildren, because a pen is not a decoration and a signature is not a formality, and he had made himself a practice of treating both with the seriousness they deserved. The ID had come out when the officer asked for identification. Quadwo had reached into the breast pocket and produced it, the way he always produced it, and the officer had looked at it and said it wasn't a driver's license, and he had agreed that it was not, and then the officer's hand had come across and knocked it from his grip, a single lateral motion, not a full strike but enough, and the card had skittered across the asphalt. He was here, on one knee in the gravel, in a gray suit, with his father's tie, on a Friday night 3 miles north of Powder Mill Road. The shoulder of the Baltimore-Washington Parkway at 9:41 p.m. in November smelled of cold exhaust and pine sap, and the particular damp of a road that had seen rain 2 days ago, and not fully dried. The patrol car's lights turned the tree line on both sides of the parkway from dark green to red, from red to blue, over and over, a rhythm that had no resolution. The sound of the highway, what little traffic there was at this hour, moved past in isolated events, a truck going south, a gap, 2 cars running close together going north, another gap, the silence between them deep enough that you could hear the trees moving at the edge of the tree line where the wind was finding something to push against. Quadwo stood on the shoulder with the credential in his hand and the gravel dust on his knee, and listened to the trees. He had stood in rooms where the sound pressure of 30 reporters with recording devices had made the air feel thick, where the weight of a single word in a draft had kept him at his desk until 2 a.m. for 3 consecutive nights, where 9 justices had disagreed about something fundamental, and the job was to find the sentence that threaded between them and held. He had stood in those rooms and kept his voice at the same register he was using now, not because he felt nothing, because the voice was the only instrument he had that he could still control, and he had learned long ago not to waste the instruments you could still control. He looked at the patrol car. He looked at Officer Marsh, who was standing with his hands at his sides, not reaching for anything now, the initial certainty of the stop having given way to something less settled. He looked at the card in his own hand, the gold seal, cream laminate, the small print along the left border that gave the credential its legal standing, all of it intact, none of it altered by having hit the asphalt. His goal that evening was to get home. He had a call at 8 a.m. Saturday with a former clerk who was now clerking for the Ninth Circuit, and who had a question about an old opinion, a 2007 majority opinion, 63 pages, which Quadwo had written and which contained a footnote 31, that the clerk thought was being misread by opposing counsel in a pending case. He wanted to talk through it before the weekend was over. He had written it down on a notepad on his kitchen counter that morning. Saturday, 8 a.m., footnote 31. He thought about that notepad while he stood at the edge of the road with gravel dust on his knee and his father's tie moving faintly in the cold air off the trees. He thought about it the way you think about the small, ordinary things that are waiting for you at home when you are standing somewhere you were not supposed to be, doing something you did not expect to be doing at 9:45 on a Friday night. The small, ordinary things are not comfort exactly. They are continuity. They are the proof that there is a before and an after, and that the after is still there, waiting, with a notepad on the counter and a call at 8 a.m., and coffee that will need to be made. Officer T. Marsh, badge number 3894 on the Maryland Transportation Authority Police, had been on this stretch of the parkway for 4 hours and 40 minutes. He had pulled over 11 vehicles since 5 p.m. He had issued 7 citations, given 3 warnings, and assisted 1 vehicle with a flat tire near the interchange at MD 197. He was 31 years old, and had been with the Transportation Authority Police for 6 years. He was not a man who looked for confrontation. He was a man who followed the procedure he had been trained to follow, and the procedure for a traffic stop was license and registration, full stop. The gold-sealed card was not on that list. He had knocked it away because it had been held out toward him in a motion he had read, in the low light of the parkway, as something other than what it was. He had read it as a push or a reach, and he had responded to what he read, and the card had hit the ground and the man had gone down after it. He was not sure what the card was. He was not sure what he had done. He stood with the light cycling behind him and looked at the older man standing in front of him with the gold-sealed card in his outstretched hand. And he said again, more quietly than before, "Where'd you get this?" "It was issued to me," Quadwo said, "by the Marshal of the Supreme Court of the United States, in October of 1993. He paused. "I can tell you the Marshal's name if that would help." Behind them, on the shoulder of the Baltimore-Washington Parkway, the driver of the dark green Volvo had gotten out of her car. "If this is already pressing something in you, stay with me. What happens in the next 10 minutes on that shoulder of the road is something neither Officer Marsh nor anyone watching from those other cars was prepared for." She was 44 years old and had been driving home from the same dinner. She had been at the table when the argument about the Privileges or Immunities Clause ran until 9:15. She had been the one who pointed out at 8:47 that the footnote everyone was arguing about had been written by the man sitting at the end of the table, and perhaps they ought to ask him directly. They had asked. He had answered for 11 minutes without notes, from memory, the way he answered most things, not because he was performing, but because he had spent 27 years thinking about these questions, and the answers had settled somewhere in him like furniture in a room you had lived in long enough. Her name was Judge Abena Owusu, no relation to Quadwo despite the shared surname, a coincidence she had explained to people at least 200 times in the 14 years since she had been appointed to the United States District Court for the District of Maryland. She had clerked for Justice Owusu Boateng in 1997 and 1998, 2 years out of Yale Law, and in those 2 years she had learned more about what the law actually was, the thing beneath the text, the reason the text existed, the standard of care owed to the people the text was supposed to protect, than in everything before or since. She thought about those 2 years regularly. She thought about them the way you think about the things that made you into the person you are. She had pulled over when she saw the lights. She had recognized the Lexus when she pulled up. She had watched him leave Justice Pauline Mensa's house from the front step and had followed 20 seconds behind him on the parkway. She had seen the stop. She had watched from 40 yards back for 3 minutes, and then she had gotten out of the car. She walked up the shoulder at a steady pace. She was wearing a dark coat over the dress she had worn to dinner, and she carried her own credentials, her federal judicial identification, issued by the Administrative Office of the U.S. Courts in her right hand held clearly visible, because she had been a black woman driving in America long enough to know exactly how you approached a traffic stop at night. Officer Marsh heard the footsteps and turned. She held up the credential. Judge Abena Owusu, United States District Court, District of Maryland. She kept walking until she was standing beside Justice Owusu Boateng, slightly to his left. "I was a passenger in a car that followed this vehicle from Washington. I witnessed this stop from the beginning." Officer Marsh looked at her credential. He looked at the credential Quadwo was still holding. He looked at the two of them standing side by side on the shoulder of the Baltimore-Washington Parkway in the cycling light at 9:47 p.m. "The gentleman you stopped," Judge Owusu said, "is Associate Justice Quadwo Emmanuel Owusu Boateng. He served on the Supreme Court of the United States for 27 years. That credential is authentic." She paused one beat. "I clerked for him. I would know." Officer Marsh did not speak for 4 seconds. "I'd also like you to note," she said, "that I observed the credential being displaced from his hand. I would like your badge number for my report." 3894, he said. The number came out before he had decided to give it. She wrote it in the small notebook she kept in her coat pocket, the one she carried to everything because she was a federal judge, and a federal judge's job never actually stopped. She wrote the time. She wrote the badge number. She wrote 3 sentences about what she had seen from 40 yards back, in the shorthand she used for bench notes, which she could read back verbatim 6 months later without effort. Quadwo watched her write. He had watched her write in exactly that shorthand for 2 years, at a desk outside his chambers, on the days when the draft opinions came back with his notes in the margins, and she translated those notes into language that the full court could work with. She had been 25 then. He had told her at the end of her clerkship that she thought like a person who understood what the law was actually for, which was not something he could teach, and which was the only thing in his experience that actually mattered. He had been right about her. He had known he was right about her in 1998, and he was watching the proof of it on a parkway in Prince George's County. At 9:49 p.m., Officer Marsh asked them to wait. He went back to his patrol car. He was in it for 6 minutes. When he came out, his supervisor was on the phone, a duty sergeant who had taken the call and had spent 2 of those 6 minutes on a separate call confirming, through the Transportation Authority police dispatch, who Quadwo Owusu Boateng was, and what his credential represented. The supervisor's instruction to Officer Marsh had been 4 words. He walked back to the shoulder. "Justice Owusu Boateng," he said. "I apologize." Quadwo looked at him. He looked at the man's face, 31 years old, 6 years on the job, standing in the cycling light of his own patrol car, having just spent 6 minutes in a vehicle learning what he had put his hands on. Whatever Quadwo felt in that moment, he did not show it on his face. He had built that face over 73 years, and the building had not been free. "I appreciate that," Quadwo said. "You're free to go, sir." Quadwo put the credential back in his breast pocket, behind the Pelican pen. He brushed the remaining dust from his knee with one more pass. He got in the car and pulled off the shoulder and onto the parkway, and drove the remaining 17 minutes home. Judge Owusu followed. She did not call him that night. She called him the next morning at 8:12 a.m., 12 minutes after his call with the Ninth Circuit clerk. About footnote 31 had ended. She said, "Are you all right?" He said, "I'm going to make some calls on Monday." The calls he made on Monday took most of the day. By Thursday of that week, a formal complaint had been submitted to the Maryland Transportation Authority Police and to the Office of the Maryland Attorney General, co-signed by Judge Owusu and by 2 other former clerks, now sitting federal judges, one in the Fourth Circuit and one in the District of Columbia, who had been notified by Judge Owusu on Saturday morning and had asked, without being asked, to add their names. The complaint was specific and procedural, the way complaints written by people who understand procedure tend to be. 5 pages, 23 paragraphs, 3 attached exhibits, and a single recommendation in the final paragraph, which was not for the termination of Officer Marsh, but for a mandatory training revision for all Maryland Transportation Authority police officers, covering the identification and handling of federal judicial credentials, to be completed within 90 days. The training revision was completed in 71 days. It included a reference guide to federal judicial and executive branch credentials, their appearance, their legal standing, and the specific protocols for handling them during a traffic stop that had not existed before. The guide covered 14 categories of federal credential, from Supreme Court bar cards to administrative office identifications to senior executive service credentials, with photographs of each and a 1-paragraph explanation of the legal authority each one carried. It covered what to do if the credential was unfamiliar, which was not to displace it from the holder's hand but to radio dispatch for confirmation while keeping the interaction civil and the holder in place. It covered the difference between an unknown credential and an invalid one, which is the difference between a question and a conclusion, and between a question and a conclusion is where most of the damage in situations like this one lived. Officer Marsh attended the first session. He did not ask to attend. His sergeant assigned him, as was the protocol for officers who had a formal complaint in their file. He sat in the second row. He read the material. At the part of the guide that showed the photograph of the Supreme Court retirement credential, cream laminate, gold seal, small print along the left border, he stopped reading for a moment and looked at the photograph, and then looked at it again. He finished the session. He signed the attestation. He drove home that evening in his personal vehicle, not the patrol car, on the Baltimore-Washington Parkway. He drove the same stretch. He noted the interchange at Powder Mill Road. He noted the shoulder, which was wider than he had remembered it, or perhaps he was just measuring it differently now. He drove it at the speed limit. He drove it all the way through. The note of thanks from the office of the Marshal of the Supreme Court was addressed to Justice Owusu Boateng. He read it at his kitchen counter on a Tuesday morning, standing with his coffee in his hand, next to the notepad that still had Saturday 8 a.m. Footnote 31 written on it because he had not yet gotten around to tearing the page off. He read the email twice. He set the coffee down. He took the Pelican pen from his jacket pocket. The jacket was hanging on the back of the kitchen chair, the way it hung every morning before he put it on, and he wrote 2 words in reply on a notepad and then typed them into the email and sent it. The 2 words were, "Keep going." Gerald Marsh thought he had stopped a man speeding on a dark road. He thought the gold seal was the question. He thought the credential was the problem, and the problem was his to correct, and the correction was the end of the story. But the credential was not the question. The credential was the record. It was the physical evidence of 27 years of work done at the highest level the law provides. Work done in a building that was designed to be the last place where the law held, where the word meant what it said, where the gap between what was written and what was true was the territory a single opinion had to close. That work did not disappear when the card hit the asphalt. The card hit the asphalt, and the work remained, in every opinion, in every footnote, in the clerks who carried it forward into courtrooms, where they now sat on the other side of the bench. You can knock something from a person's hand. You can put them on one knee in the gravel, at the side of a road at 9:45 on a Friday night. You can look at the gold seal and ask where they got it, but you cannot separate a person from what they have already made. What they have made goes on without them, holding the weight it was built to hold, doing the work in the dark the way good law always does, without announcement, without the name on the door, without anyone needing to know who sat up late writing the sentence that made everything else hold together. There are people walking among us who built the floor you are standing on. They wrote the definition. They drafted the footnote. They closed the loophole before it became the wound. You may never know their names, and they may not need you to. But they are there. And when you knock the card from their hand, you are not diminishing what they are. You are demonstrating that you do not yet know what you are standing in the presence of. That is the most expensive kind of ignorance there is. Not because of what it costs them, because of what it costs you. Here is the question I want to leave with you. If you had spent 27 years building something that existed to protect people who would never know your name, and one night someone knocked it to the ground in front of you, would you get back in the car? Would you make the calls on Monday? Or would you have something to say on the shoulder of that road that the moment did not deserve? Think about it honestly before you answer. Leave your answer in the comments. I want to read what you say. Subscribe for more stories about hidden strength, quiet power, and the people the world overlooks until they change everything. I'll see you in the next one.